thinking about going live. There we go. We are live. Um, I'll officially do a sign on, but let me just let this all get put up to speed. Okay. Guys, can you guys hear us? We have like some of the most esteemed guests here. Don't tell Brett. Just kidding. He's totally lurking in the chat. Be careful what you say about him.
I'm Brett.
Let's make sure we can hear everyone. Jason, can you be heard?
Turn my y'all filter off. Brett into for trouble. Brett has Hannah's artwork hanging up. I've got Sophie's artwork hanging up. Brett, let's do this.
Oh my goodness, someone is coming for all we need is for Jason to take the Clue Award, and then we really have a Brett in the room. All right. I'm gonna go ahead and do the sign in because y'all, the murder sheet has been awake for approximately 72 hours and they gotta get some rest eventually today, but not before they talk to us. So let me do the sign on real quick so that we can hear from their brilliance. All right. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined not by my co-host, Brett, but some of the most esteemed guests you could possibly want. Kevin and Anya from The Murder Sheet, and also Jason Blair from the Silver Linings Handbook, not filling in, please. They are the main event tonight while Brett is on the ski slopes. Welcome to The Murder Sheet and Silver Linings Handbook. Thank you for being with us, guys.
Thanks for having us. We're really excited to be here.
Yeah. And thanks for having me as well.
Well, guys, nobody wants to hear from me. They want to hear from the three of you. But for anyone who's joining tonight who may have, I don't know, been living under a rock and have no idea why we're having a live tonight, let me give a very quick blurb as to what led us up to today's hearing in the Delphi murders case. As you all likely know, Libby and Abby were murdered back in February 2017. Fast forward 7 years, we now have a man under arrest and charged with their murders, Richard Allen. As horrific as their murders are, sadly, the past few months, and really longer than that, the focus has not been on them. Rather, it's been on defense counsel for Richard Allen. Back in January, well, actually before that, last year, Judge Gull, who is the trial judge, had removed the two defense counsel, Rosie and Baldwin. They asked the Indiana Supreme Court to reinstate them as Richard Allen's attorneys, and in January, that's what the Supreme Court did. They were reinstated, but they did not do what the defense counsel asked, which is to have Judge Gull removed as the trial judge. So then we were in the situation at the end of January with former defense counsel, now as current defense counsel, back on the case in front of the same judge who had removed them. And kind of unsurprising to everybody, there was a motion filed by the prosecution for holding the defense counsel in contempt. Now, the 25 reasons listed in the prosecution's motion were not really a surprise to anyone because we knew what those reasons were from the defense's own filings to the Supreme Court when they had a transcribed from an in-chambers meeting with the judge, where the judge listed out her reasons of concern as to the defense counsel staying on as counsel. One of the kind of most shocking things that we have now known of for several months is that there was a leak of murder scene photos that were under protective order by the court, and the leak was traced back to the defense counsel. And so the contempt hearing was set for today. But that was one of many issues, actually, that was before the court today, because in the interim, there were a lot of filings, mostly filed by the defense. Several of the filings included, and I'm not going to list all of them because we'll be here all night, but the defense did ask to delay this hearing for contempt until after the trial, which is currently set for May 2024. They asked for the judge to be recused. They asked for the prosecutor to be recused. And they also listed a bunch of witnesses, for example, that they plan to call for today's contempt hearing. And, why not go for a double whammy? Today wasn't just one hearing. We had the contempt hearing scheduled, but we had yet another hearing scheduled because, like you said, there are a lot of issues going on in this case. So the court also set a hearing on the motion to dismiss. Now, that happened all today. There were no cameras in the courtroom. So how are we going to know what's going to happen in court? Well, good for us. We have Kevin and Anya who spent all day in the courtroom, and they're here today to tell us what they saw. And Jason Blair, being our journalist expert in residence here, is also going to help shed some light on a lot that's going on in this case, which involves social media, YouTubers, podcasters. So with that, let's just start off with Kevin Nananya. Thank you for being here, and thank you for being in the courtroom today.
Thank you so much.
We're so honored to be here.
Would you like to start with contempt or the motion to dismiss?
Which one came first in the day?
It was contempt. We started with a nice helping of contempt. Yeah. So sorry, we sound totally incoherent because we've been up since like 4 in the morning, and we've been at the courthouse since like about 5, which was way too early. There weren't that many people there, so I don't know what we were thinking, but we always get paranoid. What happened was Hennessy brought in a kind of 2-pronged defense, I would say. Basically, one was having a bunch of like really esteemed, well-respected and seasoned lawyers kind of come and speak and say, listen, accidents happen. This might be bad, but maybe it doesn't rise to the level of contempt, and kind of like speak to their experiences. I found that quite compelling at times because it was like, oh, these people are saying, yeah, I sent a bad email once, or like I sent it to the wrong person, or prosecutor sent one to me and I just had to ignore it. And then the other side was like bringing in like internet people, like YouTubers or internet sleuths. It's just odd because it was like such a weird dichotomy of hearing between like, hi, I'm like an experienced professional and I tried the Stephen Judy case, and we're like, oh my gosh, versus like, well, I saw on Facebook that, and you're like, why is this person testifying in court?
In fact, one of the YouTubers who was scheduled to be a witness today actually didn't appear because he got into some sort of physical scuffle outside the courtroom during the lunch break. So
2 YouTubers got in a fight.
We heard a lot about that. And, for those of us who weren't there, David Hennessy was hired by the Rosie and Baldwin to represent them in the contempt hearing. So was he the only one arguing for the defense, or did Rosie and Baldwin also make argument?
Rosie and Baldwin did not make arguments, but Rosie did testify.
Okay. So there's a lot to cover there. Now, we obviously know that both sides had witness lists, and I think what you're kind of mentioning there is we saw the witness list for the defense, and it listed a lot of YouTubers, podcasters, that sort of thing. And it sounds like maybe there was some sort of a scuffle or something with one of the YouTubers. So before we even get there, was there any sort of a hearing or argument as to whether all of the people on these witness lists could even testify?
Actually, they called the first one of those people to the witness stand, a woman named Julie Melvin, and she indicated that her testimony was going to essentially be that she's followed the case for a while, and she's seen some things on Facebook and elsewhere that maybe look like leaks. And if there's other people leaking, then maybe what the defense said isn't so bad, folks. And the prosecutor is, I'm sure you won't be terribly shocked to learn, objected to that and said, this isn't relevant to the actual facts on hand. And furthermore, whatever she says she saw leaked was not protected materials.
To me, it kind of backfired, because if you're going to bring someone up like that, maybe if you're sort of hoping to cause a little chaos, get a little buzz going, get a little conspiratorial, like they didn't even get to do that. It just was basically like over before it began.
She was on the stand for less than 5 minutes.
Yeah, and then just was kind of unceremoniously booted off by the judge, who basically said like, this woman doesn't have anything relevant.
Oh, interesting. So she was allowed to testify, and McClellan, the prosecutor, objected to relevance, and the judge ruled and said it wasn't relevant, and therefore asked her to come off the stand. Exactly. Is that correct?
That's right.
Oh, interesting. I say that's interesting because typically, as Kevin, you probably know, these relevance determinations are done before someone is called to the stand. But, this judge has been criticized by the Indiana Supreme Court and many people, who are watching this on media for not making a record. So that's certainly one way to make a record, is to have the relevance fight with the witness actually on the stand. I would say it's unusual. And the reason it's unusual, as you guys, I'm sure know from covering this, is it's a waste of time for the court, for the witness who may have had to travel and then get on the stand, and for everyone sitting in the courtroom, because that was 10 to 15 minutes that didn't have to be used, right?
Yeah,
Exactly.
Yeah, huge waste of time.
So
And there's a second social media witness who was very similar, got on the stand and started talking, and they said, what you have to say isn't relevant. So there were 2 social media people brought to the stand, and both of them were dismissed pretty quickly.
He got in a little bit more. He was talking about some of the other YouTubers who may have been corresponding with McClelland. So he hung on a little bit longer, but then sort of same thing happened, sort of ran out of relevancy, and then the judge kicked him off.
Now, and Jason, please feel free to weigh in on this. I know some people who may not be understanding these relevancy objections may be saying, it's not fair if McClelland, the prosecutor, is having these sidebar conversations about, gag order or protected material. We should know this. It's relevant to the contempt hearing. Was anything being said on the stand from these YouTubers or social media people about conversations about gag order or protective order materials with the prosecutor?
I guess
not
really. No, nothing. Yeah.
There's one YouTuber in particular who has claimed to have used the prosecutor as a source, but he never really offered any evidence of that. And he has a history of making inflated claims. And so I don't think the judge seemed to take that too seriously. And I don't think the prosecutor looked the least bit worried or concerned about it, frankly.
And one of the things that I've been curious about, it now, so you may have the answer to this question, is like, what relevance is there to what the prosecutor did to whether these guys are being held in contempt? Is it like whataboutism? Is it like, no, he did bad things too? Or like, why is it relevant whether they are communicating with creators? Because from what I've seen, right, I've seen emails that are supposedly from the prosecutor in the case to creators, and they're like, thanks for the information. To me, that's like standard, right? Like, if you don't have a public relations office like federal prosecutors have, or some large prosecutors, thanks for the information sounds pretty normal to me.
And Jason, that's a great point. And that's why I asked the question in that way, is that, communications alone with defense counsel or prosecutors is not just in general, right? The fact that you can be having communications not about protective materials, but just in general, is not barred at all. But if we're talking about protective order materials, and guess what? If that had been at issue, you would think that's the first question out of the defense's mouth. YouTuber number 1, isn't it true that Prosecutor McClelland gave you Exhibit A, which is stamped with protective order? Yes. Boom. You're not going to save it for 25 minutes into the testimony because you have to show relevance. And that's why I asked you that, because, one of their filings where they said, I'm forgetting which filing it is, but at the very end, there's kind of a paragraph where the defense says, also, by the way, Judge, we've gotten an anonymous phone call from a Texas woman. Don't name the person. Don't say when. Don't say where they got this source. And she claims to have 250 some odd pages of leaked material. Doesn't say it's from the prosecution, just says it's leaked. And it says, we're reviewing that material. So far, everything we've reviewed is public. So even in their own filings, they haven't been able to point to any leaked material that is not already public. Guess what? It's not actually leaked material when it's public. Right? It has to actually be under a protective order. So it sounds like a lot of smoke and trying to garner a lot of smoke, but it doesn't sound like, at least within the questioning of the social media folks, anything came out that was improperly given to them that was protected by a court order from the prosecution.
I'd say that's absolutely correct. There was a lot of whataboutism. It's people who haven't followed the case may not realize that earlier there was an incident where a group of people who were in a search party for the girls, right after they went missing, they came across some of the girls' clothing and they took pictures of that. And they subsequently put those pictures online. And so Attorney David Hennessy tried to suggest, well, those were crime scene pictures too. And so a leak like that is just as bad as official pictures taken by police after a crime scene has been secured.
Yeah.
Yeah.
And so it sounds like the tactic was try to say, we're not the only ones leaking materials. The prosecution's also doing it. But it doesn't sound like they were able to establish that. And I know people are going to say, well, a good journalist or a good YouTuber isn't going to give up the prosecution as their source because there's so much more of the case to go. We want more leaked material. But the thing is, this is a court hearing where they're sworn. They don't have any privilege in which they can deny to give their sources in this case, right? I mean, did that even come up where someone said, I refuse to answer this question because I plead the blank? There's no privilege.
Yeah. No, nobody did that. The two YouTubers, or kind of internet figures, I should say, were very much excited to be there. I think like they were there, to kind of help the defense. And so, honestly, it was kind of interesting. Like, and I think McClellan pointed this out at some point. The prosecutor pointed this out, noting that like some of the people we're talking about, like we maybe who wouldn't want to talk, like we don't have affidavits from them, we can't like question them, like they're not here. All we have is like some person who claims to have seen some Facebook posts and like nothing else. And I think that hurt them because we weren't even really getting like the people who might have been more directly involved with whatever the defense was alleging.
And Alice, to your point, by the way, about getting on the stand and not having any privilege, like traditionally, like, and two of my colleagues when I was at the New York Times did this, right? They got up on the stand, they were questioned by the judge, they were asked to reveal their sources. They knew there was no privilege and they said they're not going to do it. One went to jail, one worked something out with federal prosecutors. But something's changed in the current, certainly the true crime creator space. People are constantly giving up their sources because they use giving up their sources to get more sources. And it's the most absurd thing I've ever seen. But when you're driven, I think, in a universe where I guess truth matters less than clicks, people will turn on their sources. So certainly I could see some of the creators within the space actually seeing it as a badge of honor to get up there and say that some of these people were their sources, right? It'll get them more clicks. People will view them as insiders. I mean, it's absurd on some level, right? Because you're going to lose your sources. But look, none of these folks, or let me rephrase this, a lot of these folks are not going to be splitting the atom anytime soon. Or like I said to Kevin and Anya, not going to put the man on the moon. So, I wouldn't be surprised if they actually did have sources that they would have gotten up and said it.
I will say this. I mean, you mentioned that. I remember recently I nothing related to Delphi, but I was, not so long ago, I was in a deposition about like, again, nothing to do with work. But at one point they wanted my phone. They were like, oh, we're going to look through this for the subpoena. And we basically had to like fight like hell to not let that happen, because I was like, they're not going to be seeing anything that is any way related to work. But like, if there's a mistake and they see stuff like that, could damage me as a journalist because it would hurt my sources. And like, Jason, you hit the nail on the head. Like, there's so much gossip in the Delphi internet space. Gossip and in some cases, facts or sources are like a currency. And sometimes people go out and spend it all in one place, essentially, in order to get attention or to satisfy whatever itch or to settle a feud. And it's not a professional, journalism became professionalized over time. And really, YouTube to me represents the wild, wild west. And I mean, it kind of is disheartening. And I'm sure you guys feel this too sometimes, where it's like, we're all in this podcast space, which can be wonderful. And like, both of you have an amazing shows that like I love to listen to and feel like I'm smarter for having listened to. But sometimes you feel like because it's just so new, there is sometimes like this underside of it.
Well, and I'm not sure it's YouTube, right? Because we're on it right now. But I think like there are 4 buckets, right, of true crime creators. There are your traditional journalists like Connie Walker, who did Stolen, or you over at Murder Sheet. They're like your advocates. There are people who are like analytical analysts, like Brett and Alice, and then there are entertainers. And there's some like crossover, right, between some of those groups. Nothing's inherently wrong with any of them. But I think there are two things, right? That irresponsible creators tend to have very little regard for the truth, whatever their motives may be, and they operate in bad faith. They operate in bad faith with their sources, they operate in bad faith with the facts because, like, for example, I'll give you one from last week. One creator who I know and I know is not insane started promoting, well, possibly, but anyway, they started promoting a rumor that all the defense attorneys and a bunch of creators were going to get arrested today. And literally, they were saying, yes, I'm not even kidding. They were literally saying that they were going to get arrested today. And I'm sure it got them plenty of clicks and lots of attention, but I know this person does not believe it. They did not believe what they said. So, we're in an environment where, and I think Alice would probably agree with this, there's less and less in the media or the creator space that you can really trust, that you can take home, that it's accurate. It was hard enough in the good old days because, when I was at the Times or the Washington Post, we got stuff wrong all the time, but we tried to operate in good faith.
And that's absolutely right here. We'll keep moving on because we're like, I don't know, maybe 10 minutes into the hearing that lasted all day today. And I know these people are not going to go to sleep until they hear what happened. And you guys need to go to sleep. But that's the problem here is we are seeing the convergence in a terribly ugly way in this particular case, where the worst of true crime kind of social media world, where we can have entertainment, we do things for clicks, has now converged with real life court. And it is not being checked at the courthouse doors, as we see in a lot of other cases. Oftentimes there can be insanity happening on TV, but what's actually happening behind the courthouse doors abides by the rules, the model rules of ethics, the rules of evidence. And in this case, it seems that we've kind of skirted all that. So, like, did the defense call the rest of their list, and how did the witnesses go from there?
So they did not call the rest of their list. There were only those two social media ones. So they had a couple that they left on the table.
Let me ask this, because I'm sure people will say they were prevented from calling their list. Were they prevented? Did the judge say no more people on your list, or did they choose to forego the rest of the people on their list?
It seemed like they chose to forego them because there was no discussion.
They did call 3 veteran attorneys, I think you mentioned.
3 veteran attorneys who, did a good job, seemed very credible, and like kind of just spoke to their experiences essentially.
As to what rose to the level of contempt in their legal experience. Is that right?
And of course, they called Brad Rosie to the stand. And what's interesting about that is most of the questionable acts under discussion seem to revolve around attorney Andrew Baldwin and not Brad Rosie. And they don't call Andrew Baldwin to the stand. They call Brad Rosie to the stand.
So how did that go?
It was kind of awkward. I don't know. I mean, personally, there seemed to be a little bit of tension between David Hennessy and Brad Rosie. I don't know what that was about. There were also a lot of auditory issues, like Hennessy not hearing people not hearing Hennessy. In fairness to Hennessy, the acoustics in the courthouse were weird. I mean, it wasn't good. And so basically, Brad Rosie was saying, I didn't really have anything to do with this. If Mitch Westerman walked in here right now, I wouldn't know who he is. So he's basically sort of, I disavow everything. I kind of am just like caught up in this.
And I also thought it was interesting because David Hennessy tried to make the point that, so Andrew Baldwin at one point accidentally, by his own account, sends an email with discovery materials to a party outside of the case. And Hennessy tried to argue, this isn't a big deal. You shouldn't feel like you have to immediately go to the judge because of this. Happens every day. Who hasn't accidentally sent an email? And then when Rosie testifies, he said, well, I didn't know about this incident for a couple of months after it happened. But well, when I found out about it, I immediately went to the judge.
I mean, that's really interesting. There's several strategic reasons to have Rosie testify rather than Baldwin, because you hit the nail on the head. Baldwin is the center of certainly the email that was errantly sent, where he did not notify the court. And just by the way, it didn't end there, right? The email wasn't deleted. We know that the materials ended up on YouTube and was then disseminated to other social media creators. So there was absolutely harm done in that case. And second, of course, the leaked crime scene photos are also led back to Baldwin's office. So I understand him not testifying because, dude, you'd have to like plead the fifth a whole lot because there's a lot of stuff there, which is when your own attorney, David Hennessy, in a previous filing before the attorneys were removed the first time, said, yeah, this is probably contempt. You're kind of in a pickle when you're now in a contempt hearing based on the exact same facts that your attorney said back in the day. This is contempt, but please, please don't take us off the case. So to have Rosie on the stand is interesting, especially because the recent filings by Hennessy on behalf of Rosie and Baldwin put the royal we in there. Like we, Baldwin and Rosie, did X, Y, and Z, but it's not to the level of contempt. So do you think that in some ways Rosie was supposed to like take the fall for both of them, but then by taking the stand, showing how he himself has no real tie to these missteps, that it could then be imparted onto Baldwin, that, somehow because Rosie didn't know, that means Baldwin shouldn't be to blame either?
Yeah, it's a really good question. I don't know what the strategic thinking was. I almost was like, maybe they were trying to like throw it out there, like, you can't blame this guy. It's not his office. He doesn't know these people. I mean, he didn't even do the email thing. Like kind of just putting out like one of these guys doesn't look so bad in all of this. And maybe like hoping that then people just kind of, I don't know, see, he's standing by Baldwin, so how bad can it be?
Well, of course, I'm reminded that there was a meeting in chambers before the attorneys were pressured to withdraw from the case, where Brad Rosie put it out there. Well, maybe why don't you force Baldwin off and leave me on? So maybe there's a little bit of maybe focus more on him than on me. Another thing that Rosie said that I thought was interesting, another one of the issues under discussion, is that there was some sort of a meeting in the judge's chambers to discuss a gag order, whether or not they need a gag order in the case. And Rosie and Baldwin said, no, we don't need a gag order. We have absolutely no interest in trying this case in the media. And then they go out and they issue a press release about how Richard Allen is obviously innocent, arguing for that. Rosie said today that his purpose in sending out that press release was not to try the case in the media. He just wanted to make Rick Allen feel supported. Yeah.
Well, I mean, lawyers are masters at reframing, so that's one reframing. Here's another question that maybe you guys get a feel for from being in the courtroom. Rosie taking the stand, I think, says a lot about his own culpability in the allegations at issue in the contempt hearing, which is to say that it seems like he has much less culpability. Contempt is a huge thing for an attorney to face. There is always the option to split defenses, right? For Rosie to be on his own facing the contempt hearing, having an attorney for himself saying, I didn't know about any of these things. Like the things that you've listed that are very serious, I had no part in. Contempt should not be something against me whatsoever. And Baldwin, basically having to have Baldwin go down his own path. Did you see any sort of a split within the veneer of their jointness? I know you said Hennessy may have had some tension with Rosie, but they've clearly made the decision to go about this together. Maybe, it's harder to break two chopsticks than it is to break one, as the old Chinese idiom goes. But did you see anything like that or any indication as to why Rosie was sticking together with Baldwin?
It's a great question. And to be clear, maybe some of the tension was just the auditory thing, of like people becoming frustrated with that. I feel like we've really seen them sticking together quite a lot, like being quite, very much a team in this together, when you might expect Rosie to throw Baldwin under the bus. Because I think if you've ever been in a group project with someone who's just, not like just a disaster, you might have that inclination to be like, well, I deserve an A, like this person deserves an F. We've not really seen anything like that. And I think your point is really a great one. Like if you split them up, Rosie can possibly skate while Baldwin ends up facing, the more serious consequences. So the fact that they didn't do that tells me that they're very much, in sync and sticking together.
Was Rosie asked about the leaked photos? What did he have to say about it?
So one of the things that was said when one of the prosecutor's witnesses was one of the investigators, and we can talk about that more in a moment. But this investigator indicated that as soon as I heard a description of the pictures, I knew it had to ultimately come from the defense, because these were pictures that were specially prepared for use in defense depositions. And Brad Rosie on the stand said he had never actually looked at the leaked pictures until his lunch break today. And when he looked at them on his lunch break today, it seemed to him that a couple of those pictures were not from defense depositions. And he was then asked, well, were any of them from defense depositions? And he says, well, there is a screenshot of a screenshot, so who can tell? I think that was his most extensive discussion of the pictures.
Yeah.
Wow. So he said he'd never seen the leaked photos before today.
Before today, his lunch break. So that was interesting.
It's really interesting. I'd like to go back and read some of his filings where he filed alone after he told the court he was no longer going to withdraw, about the lack of seriousness of the leaked photos. I can't recall it off the top of my head, but he made some allegations in those filings.
And now he's saying he didn't even see the pictures of the time he filed that. That's interesting.
Curious.
We're all using interesting words here.
That's the thing about all of these. I mean, obviously he was under oath, and these are tough questions. I'm not taking this lightly. It's probably my worst nightmare as an attorney to be having to testify in my own contempt hearing. Were the questions all directed about really Baldwin? Or, I mean, I don't quite understand why he took the stand, to be completely honest.
That wasn't clear to me, to be completely honest, either.
A lot of this was not clear to me about why things were done the way they were.
Okay, and that's helpful to know, since you were sitting in the courtroom. Was he the last witness for the defense?
The last witness for the defense. The prosecution opened with witnesses. Their witnesses were some of the investigators who, basically looked into it. And that there were some awkward moments there for us, because we do not particularly enjoy being mentioned in court. And so I would be remiss if I didn't mention, we received these leaked pictures. And then, with the permission of the person who sent them to us, we immediately notified the state. We also notified the defense. The defense didn't ask us a lot of questions about them. The state was very interested in them. And so they were interested in them. We talked with them. We shared screenshots of communications between the person who sent them to us, Mark Cohen, and the person he received them from. And so all of this was discussed in court today. Anya and Kevin did this, Anya and Kevin did that. And it seemed apparent that having us discussed in court that way not only made us uncomfortable, but it seemed to indicate that Hennessy, and maybe the defense team as a whole, for all I know, are not big fans of us. Because then they brought up the fact that at another point, Anya and Kevin released a search warrant and the affidavit for the search of Ronald Logan's property. How on earth could they have gotten this without some secret source from the court? And what they neglected to mention is, it's very well known that Mr. Logan copied those documents, which he had lawfully, and sent them to a bunch of reporters and a bunch of people in the Delphi community. And it's well known that another reporter has these documents and got them directly from Mr. Logan.
Those have been floating around for years in the background, and we were the first to publish
them.
So
they were trying to suggest something sinister to discredit us.
But it was like not apples and oranges. It was like apples and beef, because it was like okay, like, so something that happened before there even is a protective order or a gag order about a different guy, like where he, they got out through the guy they were about and spread all around, and then that we published is somehow on par with members of the parties being implicated in a leak as we're heading towards trial and in an actual case. Like, it's just, what?
That's a really great point that you make there, Anya. So I assume this was brought out in cross-examination, that he was insinuating that there were other
Yeah.
things. And the reason you do that in cross-examination is just to call doubt on whatever is being testified to. But if you were actually trying to set forth a fact, which is that murder sheet, got access to information from the prosecution or what have you improperly, they would call their own witness and have it affirmatively put up rather than cross-examination, which is simply to poke holes and kind of draw doubt onto the testimony that was just held. But did the defense call anyone to figure out? For example, they could have subpoenaed y'all and asked you
Yeah.
your source, correct? Were you subpoenaed
Yeah.
by them to testify?
No. And also we've been, we've been open to the extent of we don't want to name our source, but we're happy to kind of at least give a sketch of the atmosphere in which this document sort of got out there, and it's basically nothing.
It wasn't anyone affiliated with law enforcement or the courts or the prosecution.
If this same gag order had been on this at the time, they would not have been the person. They would not.
Was not covered by
it. Yeah, this person was not covered by it.
Yeah, and that's a great point. This material was not covered by the protective order, and also it is not relevant. We've talked about relevance at the very beginning with the two YouTubers. This just isn't relevant for the allegations at issue here. It's not the same. There's no protective order here. It's not the same individual at issue. But I understand from your perspective, sitting in the courtroom, how existential it can feel being talked about, especially if you feel there are untruths.
He kept on calling us the murder sheet people.
I like that brand. You need to make a T-shirt with that.
Yeah, I like it. Yes. Are there murder sheet T-shirts yet? Should we? Yeah. Okay. All right.
Jason just volunteered to make murder sheet people shirts.
Yep. I know the people. I did have a question about that. The initial prosecution witnesses thinking about it from the media creator space. Was there any indication or any question? That gave you any questions or indications that give you any insight into whether the leak was believed to be intentional by the defense or that it was accidental?
They danced around that a lot.
There was a lot of dancing. Around that. It was at one point they asked one of the investigators, like, well, you could never prove that one person who was a part of the leak was connected directly to Baldwin. And the response was like, yeah, I was never able to prove that. So it sort of indicated to me that they looked into that possibility that this was purposeful, and we're not able to find enough evidence to prove that.
And then there were other little things like a side issue that came out of all of this was that during the investigation, police were able to access the iCloud account of Mitch Westerman. This is the person who took the photos of the crime scene pictures that were supposedly on Andrew Baldwin's desk. They access his iCloud account, and in it are a lot of screenshots of communications between him and someone named Andy, obviously Andrew Baldwin. And the defense was trying to suggest it was improper for the prosecutor to look at this material because wasn't this work product? And the prosecutor says, well, if it's work product, are you acknowledging that Mitch Westerman was your employee and your agent? And if that's the case, what does that suggest about the original leak? And Hennessy said, just because you say something in cross-examination, it doesn't count.
And that's having your cake and eat it too, is what he was trying to do, right? Just so you guys know, work product is a legal term. It means that you don't have to turn over information that is prepared in preparation for litigation. But the second it's shared with outside sources like attorney-client privilege, it's no longer work product because it is shared. And the whole point here is Westerman is not part of the defense team. They've made very clear, the defense has, that he is some random guy that just wandered into Baldwin's unlocked office and, unbeknownst to his good friend Baldwin, snapped some shots and stole these photos, which, by the way, doesn't change the fact that Baldwin's office was unlocked and the materials were left out in order to be taken advantage of, right? I think that's been the allegations all along by the prosecution, which is that there is no allegation or that they've been able to prove, so they haven't made these specific allegations, that Baldwin handed any of these photos to Westerman or any third party. Rather, he created the environment that was that created the opportunity for violation of the protective order. And we all, in all of our different professions, have obligations to take measures to protect materials, especially when there is a court-ordered protective order in place. So, that could be lost in a lot of the discussions here, but am I correct on that? No one got on the stand and said Baldwin handed over materials to a third person. All along, it's that he created the environment that allowed such a leak to occur.
Yeah, they were arguing basically like negligent homicide rather than murder, essentially. Like this was a negligent situation that got out of hand rather than this was an intentional plot to spread these around.
Gotcha. Yes. But then that's really interesting because my understanding, and you touched upon this, is they obviously found out about the leaked photos. And then in investigating how the leak occurred is when they found the screenshot conversations about the defense's strategy that were really in violation of the gag order between Westerman and Baldwin. Is that correct?
Yeah. Well, there's two sets of screenshots because there's also the screenshots of communications between Midge Westerman and there's also the screenshots of communications between the man who later took his own life, who we call R, and Mark Cohen. And in those conversations, there's a lot of issues discussed about defense strategy. And so it's very clear that R knew exactly what was going on. And that was highlighted today. They would refer to things like, well, this happened on such and such a day. And look, 2 or 3 days later, R was writing about it to Cohen.
Like, oh, they just got the girl's cell phone records and here's what it means. Or, they just, Andy's going to run up to Fort Wayne and file this. It was like,
and to be clear, R was not part of the defense team.
No.
That's correct.
Correct. And that's kind of what, from my perspective, I was curious about whether law enforcement would push that point of intentionality, because there are clearly things that there is no document for them, that they were at least clearly in their text messages or their different messages, they were suggesting they were getting real-time information. It's like, I found out what Alice had for breakfast this morning did not get leaked 3 days ago, or unless you plan that far in ahead. But, it's real-time information. So that raises all sorts of other questions.
It really does. And there was a lot of suggestions that this was not just a one-time leak. It was an ongoing matter. And if that's the case, what does that suggest? And then in addition to that, there's these screenshots of communications literally between Westerman and Baldwin. And those were sealed because they said in addition to some talk about the case, they also have some of Baldwin's and Westerman's impressions about people.
The tea was too hot for the court, so we don't get to see that. I wonder who they were talking about, like, honestly.
And that's a really, that's a really astute observation there, which is that here we have not just one instance. So people who are saying it's not so bad about the leaked photo because Baldwin was hoodwinked by his friend. He had no idea. First of all, we've had this fight before. It is a very bad thing that these documents were just out there. He had an obligation to keep them safe. Let's not dwell on that. The whole point is the contempt motion listed 25 reasons. And what it showed was a pattern and practice of repeated violations of not only court orders, but simple due diligence and duty to your client, which is Richard Allen in this case. An attorney should never be breaching an attorney-client privilege. The only person who can waive that is the client himself. And guess what? If they could show that there was no breach of attorney-client privilege, they would have called Richard Allen to the stand, who I understand was in the courtroom today, to testify to say, of course I knew he was talking to R. Of course I knew he was talking to Westerman. I told him to do that because I trust those guys. They have insight into my defense that my attorneys can't have otherwise. So I waived it. They didn't do anything that I didn't know about. Guess what? If they did that, boom, bang, done. No contempt. Did they do that?
No.
Well, darn.
Have you ever heard of a leak like this? From my journalist side, I've never heard of a leak where it literally accidentally leaked out of the prosecutor's office. I've heard of plenty of leaks and been a part of plenty of leaks where like intentionally stuff was passed on, but I've never heard that they're so sloppy that it somehow ends up in troves in the media. And I would imagine any prosecutor that I covered would be looking for a new job if they accidentally leak this information.
I mean, I have no. If this happened to me, I would probably lose my bar license. Any prosecutor would. They would not only lose their job, they would have a duty of candor to the court to immediately fall on their sword in front of the court, mea culpa, report themselves to the bar, and probably have an open investigation within their department, whether it's the state, whatever your entity is, that your jurisdiction would open an investigation into you. It doesn't go away immediately because it's that serious. Even if I left it on my desk and I left because I needed to go to the bathroom. I dealt with those materials all the time, especially in, say, the child pornography case. No, I did not ever leave any child pornography evidence open. I had to go into a special room where I left all my electronic devices, my phones, both my personal phone as well as my, work phone, and walked in a cipher lock, which meant it was a code that was to me so that you could tell who went into that door, because we all had different cipher codes, so I couldn't blame it on someone else later. Oh, Brett went in after me. No, Alice, that was your cipher code. I went in and I log in the time and my name and my signature and which exhibits I'm checking out. Checking out as in the room. I view it on a special computer that does nothing but that particular material. By the way, did I have to do all of this? Would it have been sufficient if I just had a folder in a locked room? Probably. But the reason we took all these measures was because we had a duty to abide by the court's orders, and we took that duty very, very highly. Did it cost me a lot of time to check in and out every single time I had to look at these materials? Heck yes. And real quick, I know there's some discussion about having to go through 250 pages or 120 pages. This is impossible to do before trial in May. Just as a tiny little exemplar, this weekend I had a very pressing matter in my day job as a lawyer, and I personally reviewed 2,300 pages. No, documents. Documents meaning each document had multiple pages. By myself on Saturday and Sunday. And I had to parent full time. It killed me and I stayed up all night, but yeah, I did it. And I did a really good job of it. So complaining about having to review 250 pages before trial in May, cry me a river. You're an attorney. This is what you do, right? All this to say is these are very serious things, but I think there's so much misinformation out there. There's not a lot of people speaking the truth because you know what? It doesn't get clicks. No one wants to hear me talk about how easy it is to just protect your materials. People do it every day. Doctors do it. Teachers do it with student report cards that have social security numbers on them. Your doctor with your chart, with your vaccines and your history and any diagnoses you have, they have a duty and they do it every single day. And it is not only expected, but you will lose your job if you don't do it. And so to say that you didn't intentionally hand over a document, we've had this conversation many times. And I think the majority of people who have jobs out in the world can recognize a duty upon them that is incumbent on their role in having access to sensitive materials.
And one of the defense arguments, I would love to hear what your thoughts on this are, Alice. One of the defense arguments has been, hey, we're not like prosecutors' offices in the state and they've got these huge budgets, but I kind of figure my therapist keeps my information confidential. I mean, my pet sitter keeps my information confidential.
Yes.
But that said, I mean, it's not, there are other ways. You don't need to skiff, right, with a cipher lock, but there are other ways to keep stuff away from people. We keep it away from our kids every day.
And again, it's not just this one instance of a leak. I could imagine if it just was this one picture. I had a terrible day. I was throwing up. My friend was bringing me Theraflu, and he walked in and took pictures of my materials. I was throwing up so much I didn't have time to lock my door. No, we have real-time screenshots of conversations where this is the pattern in practice. And I think that's important to note here. Not a one-time event. This is what led to one of the most egregious leaks in any case I've ever heard of. And it didn't happen out of nowhere. It happened because of this pattern and practice of over a year of being incredibly loose with that divide of attorney-client privilege. And you know who's suffering here? Richard Allen. Richard Allen is the one who suffers day in and day out. I know that we have not even mentioned Libby and Abby's names here, who are the real victims, but Richard Allen deserves a constitutional trial and competent defense. And the reason this matters and that this hearing is not some ancillary matter, as the defense has claimed in their filing, that should be held after trial, is because it goes to the very core of whether Richard Allen is going to get a fair trial. And they know this. The defense knows this. Absolutely. So I just don't want anyone to, lose sight of what's at stake here. I care about Richard Allen's constitutional rights. We've always told you the prosecution cares very much about that because you want to protect your conviction. And this has turned into such a circus that we're really losing sight of the girls who are the real victims, as well as Richard Allen, who is facing very serious charges. Let's talk real quick. Everywhere in the news, you hear all these news things. Oh my goodness, the kidnapping charges have been tossed out by the judge. What really happened, Kevin and Anya?
It was actually kind of really breezily gone over at the very beginning, where McClellan said something about God, I don't quite remember what the phrasing was, but it had to do with statute of limitations, and was we're bouncing in, basically we're knocking these off, and then the defense was yep, that's fine with us, and that was it. It wasn't really a lot of fuss. It was sort of a blink and you miss it moment, even though it certainly seems like a big deal from the media perspective. I can understand that, drop charges. That sounds great in a headline.
Wasn't the dismissal brought by the prosecution?
Yeah.
Yes.
Yeah. They were we're not going to go for this. Yeah.
And that happens all the time, right? So when you first charge a case, you can bring lesser charges because you are still investigating your cases. And the thing is, if they're going to bring murder charges against Richard Allen, at some point he had the girls under his custody and control that probably met the definition of kidnapping. So it's not that they don't have the facts to prove kidnapping. It's that you don't need it for a murder trial, right?
And kidnapping is the felony in their sort of felony murder charge that still is.
But
now it's murder. So they went from, it's almost like they went from kidnapping to murder, if that makes sense. Because initially Indiana we don't call it felony murder, but the murder statute.
Yeah, kidnapping that led to a murder, as opposed to, okay, we now believe this person murdered this person. Right.
Exactly. So they're kind of, it's a progression, I think.
Before we leave the contempt, I should say that the way it concluded was that Hennessy says, I want to write a memo about all of this for you to consider. So he has a week to write that memo, and then the prosecution has a week to respond to it, and then the judge will issue a ruling within 30 days after.
And then it'll be time for the trial.
And thank you for putting that out. So there was no ruling by the court today, but rather a briefing schedule set by the court. Is that correct? Is that right? And I know we've talked about this, but kind of recapping the contempt hearing, in terms of Hennessy asking to be able to write a memo, what were the major facts that came out today that we didn't previously know from the many filings?
I'm not sure I can think of one. Can you?
No. There
was some from the prosecution side, some of the details of the investigation. I don't think that's out there before, about how they tried to get into Mitch Westerman's phone and they couldn't, some things like that. But the defense was mainly presenting stuff, as I say, a social media person who said she saw some leaked stuff on Facebook once.
It felt very rushed. I'm just going to be honest. It felt very rushed from the defense on this. And if I were Rosie and Baldwin, I would not be. I felt like there could have been a more compelling way to frame some of this. And it just didn't happen today.
Was there any indication by Hennessy what he wanted to address in the memo? Because usually in court, if you've already briefed up an issue, because both sides have filed things, you would say something like, Your Honor, this is new information that's come out in XYZ testimony today. I'd like the chance to respond in writing. So did he say anything like that or give any indication of what he wanted to respond to in a memo?
He did. He just said there's some issues I'd like to discuss further in a memo. Can you give me a little bit of time? And she said, how about a week?
So overall, how long was the contempt hearing?
The contempt hearing started at 9. It ran until noon, and then there was a lunch break, and then it reconvened at 1 and ran until I think about 3:30, and that's when the motion to dismiss hearing was.
And that was 2 hours until 5:30.
Okay, so we've gone almost an hour. I don't want to keep you too long, but I know people want to hear more about the contempt hearing. Is there anything else that, you observed throughout the, 5-6 hours of contempt hearing that, you can tell us about?
I I would say that I don't know. It seemed like I felt Hennessy seemed to be kind of all over the place, and I just felt like, again, maybe some more cohesion to what he was doing. And then honestly, just like it kind of like when he's like lobbing stuff about us that we know for a fact is like not really relevant to this. It kind of like it's like underscoring that like maybe sometimes things are said to score points or because it sounds like it's part of a narrative rather than because it's like super relevant here. And I question doing things like that because I feel like your credibility and your reputation like are important in this. And when it's like being squandered on like, let's hear what some Facebook lurker thinks, or like, I feel like, I don't know, just kind of baffling. The whole thing was just like odd. It was
There were a few occasions where he would mumble something that we couldn't hear, but the judge could hear, and it would make her angry. She'd say, like, "That's very inappropriate, Mr. Hennessy," or things like that.
Yeah, and he was getting people's names wrong left and right. I mean, it was just like I don't know. It was like hard to watch at some points because it was just like, what is happening here? Like it felt very thrown together at the last minute, even though they've obviously had a long time to prepare for this. And so I didn't feel like it was super effective, and I don't understand why, because I feel like there were some good arguments in my opinion. And I think we even saw some of them today. I just feel like they got buried under a lot of other noise.
Were there closing arguments after the witnesses were called by both sides?
Yeah, there were.
And can you kind of recap what each side's closing argument were after, all the witnesses they chose to put up?
McClellan's got into the emotional impact of how this is something that the families are going to have to live with forever, and going to have to always worry that some creep on the internet is going to send them, and like that's horrifying. And sort of the emotional core of all this is like making a tragedy worse, and also basically like flaunting the court's rules, undermining the defendant at the heart of this, and sort of summing all that up. What did Hennessy say?
Hennessy was, everybody leaks, things of that.
Don't worry about it. I don't know. Yeah, he kind of just rattled off, like, he was kind of all over the place.
So it sounds like it wasn't any sort of a Matlock moment for either of them.
No.
And neither, frankly, was the motion to dismiss.
Yeah, we can talk about that. We should talk about that.
Yeah. Let's real quick. When do we, based on the briefing schedule, does that take us into April for the briefing? So end of April for both sides to be able to file the memos that were requested by Hennessy.
And then 30 days after that until the ruling.
Got it.
I think it's into May, and then the trial's also ostensibly in May.
Got it. So we won't know anything until May. Obviously, did they talk about the potential actions that could be implemented by the court if contempt was found? Did Hennessy make any arguments like don't put us in prison or anything like that? I don't think that's going to happen, by the way.
He did sort of say like, well, this speaks to like what happens if there's a punishment, like if it comes to that. So like he did bring it up, but like not super directly.
Okay. Just for the record, I mean, contempt can be as simple as just a ruling that there's been a finding of contempt with no real consequences. It could be a financial, fine. Yes, you could be held in civil contempt and like thrown in prison. I don't think that's going to happen here. Removal, I guess, is another option. I don't think that's going to happen because of the history of this case. So in a lot of ways, this is an exercise in trying to get onto the record all the things that the defense argued was never on the record when they went up for mandamus to the Supreme Court.
Yeah.
Okay, so you guys barely got a break, and then you came back for round 2, motion to dismiss. Can you lay out what this motion was about and how did it start off?
So back in 2017, in February of 2017, the defense's suspect, Brad Holder, was interviewed at the police station. This interview was recorded on a DVR, and then a memo was written about it. The DVR is something that's supposed to only be turned on when an interview occurs. But for some reason, it was speculated today that it was because of a power surge or something of that nature. the settings in the DVR got switched to do a continuous record. And because of that, several days worth of recordings were lost, including this initial interview with Brad Holder. And even though Holder is still available to be interviewed, and even though there are memos recounting the interview, the defense maintains that this interview itself would be so exculpatory. The fact that we don't have it available to us is a sign that the case needs to be dismissed. And so one thing they needed to prove today to get over the hurdle was they needed to establish that in 2017, at the time the interview was erased, that the police should have known that it was an incredibly important interview. So that therefore it was like a real act of negligence or something worse for this to happen. And if you could prove that, then perhaps Judge Gold would dismiss the case. And so what was interesting is that Baldwin called, the first witness he called was Todd Click, who's one of the investigators who investigated the Odinism angle. And instead of talking about what police should have known in 2017 or what police did know in 2017, he started going into all the details of Todd Click's investigation, which started after 2017. And there were some objections, and Baldwin kept saying, well, I'm getting to it, I'm laying foundation. But it seemed like a way just to get all of the Odinism stuff back in again. And finally, the judge lost patience with the whole thing. Another witness was called, Brad Holder's former wife, I believe, Amber Holder.
Yep.
And again, this was focusing on things after 2017. The judge called counsel to her bench, and at times she was speaking so loudly that we could hear the things she was saying. Like, if you don't have, she said at one point, if you don't have witnesses to 2017, you are wasting everyone's time.
Yeah. And like, I mean, I called it, I was like, this is the Frank's memo, the dance hall remix. I mean, it was like, we're not really getting a lot of new information. I found it very interesting to hear from Todd Click personally, because it's like he's been sort of a central figure in that theory. But I honestly kind of felt bad for these witnesses because they came up here, they came, to testify, and basically like it wasn't, I guess, the appropriate moment. It wasn't something that would actually speak to the issues of like
2017.
Yeah, should this case be dismissed? So it's like
it's like going to a football game with a baseball bat. He wasn't prepared to do what he needed to do in order to win his motion.
And so kind of to lay the groundwork, I know we just did a little bit about face. So contempt hearing, Hennessy was the attorney because the subjects of the contempt were Baldwin and Rosie, the defense attorneys. But the motion to dismiss was filed by Richard Allen's attorneys, and it's to dismiss the case. So Baldwin and Rosie are back now as defense counsel. Hennessy's no longer part of this particular hearing. And specifically, they were saying that because there were interviews, is this the April ones or the February ones?
February one.
So I think a few days in February of 2017, remember the girls were murdered in February 14th, 2017. So right after, really within weeks, in the first weeks of the investigation, Brad Holder was interviewed. And if there had been video of it, it had been lost back in the day. And it sounds like what they were coming in to do was to essentially have a Frank's motion based on their Odinism theory, which, of course, had been denied by the judge previously. Is that that's the sense I'm getting here, is they called witnesses to talk about really what they wrote about in their Frank's motion?
Yes, instead of what they wrote about in their motion to dismiss, which was actually the subject of the hearing.
Yeah, there's often, I mean, I've noticed this, there's been often a mismatch between what they're trying to, the facts of what they're arguing and like what they're asking for. And to me, I mean, I feel like part of this, like, kind of like tips their hand on like possible cross-examination strategies during trial. Like, I think this might be a good strategy to say, like, law enforcement was sloppy. They lost this. What the heck? Maybe a jury finds that credible and says, yeah, that is kind of messy. But when you're like sort of telegraphing it this early and it doesn't really do what you want it to do, I don't know why you're doing it.
That's a great point, Anya. We've said that before, right? They can argue this all day long, and they should. This guy, who's your real guy, was interviewed, but we don't have access to it. Let me ask may seem like a silly question to you, but I think it's relevant for others to understand why this is not as big of a deal as defense is making it out to be. Is Brad Holder still alive today?
Yes.
Yeah.
So he can testify. He can be interviewed. He can be subpoenaed. He can be interviewed and testify under oath upon either the prosecution or the defense, right?
Yeah.
And the only thing, that previous testimony, those of you who've listened to our hearsay episodes, is actually not in it of itself admissible as evidence because it's hearsay. Now, of course, if he said something completely opposite, if he said, I killed the girls in those recordings, and then now is getting on the stand and said, I don't even know what you're talking about. I never even saw those girls. They could impeach him with what he previously said, but it's not evidence that he previously said, I killed the girls. But that's not even what's being alleged here, right? Because they haven't even shown that what's been lost was exculpatory. Is that correct? Did they try to put on any witnesses that it was actually exculpatory?
Yeah.
This
They did not. Yeah.
begs a question. You guys have pointed out, Alice has pointed out, Kevin, Anya, you guys have pointed out a number of things that just don't make sense. Why would you do it in this hearing? Why would you do it this way? That you're giving them a preview of things. So it begs the question, why would you do it? So this is something I've felt for a long time. If you change your lens and stop looking at the defense team's focus being on the jury, and you look at it being on the media, then all of it makes sense. It makes sense why to talk about Odinism. It makes sense to why to try to undermine things. So, to Alice's point before, I sort of feel like we've gotten to this point where we've lost sight of the girls and justice, right? Which is the implicit reason why we have all these things. We've lost sight of the explicit rights of the defendant given in the Bill of Rights, right? And what we're really focused on right now is pandering to the headlines of the day for the media. Now, I understand, right, that's just, it may not be true. It may not be realistic, but it certainly leaves the impression that the real jury for all of this is the media. Why else would you do these things?
Do you view that as like a goal for like helping in appeals or like a movement to free Richard Allen down the line? Or like, I guess like why would you do this?
Well, I were covering the coverage. I would look at it as a great way to turn yourself into the next Jose Baez, right? Or to get a movie deal. This is all great for it. All the drama, all the being removed, all this stuff, it makes a great movie. And if you are somehow also successful in getting the defendant off, not that I want to accuse anyone of ill will, then you've got the combination of this great narrative and you've been successful, and don't get me wrong, like people should look out for their own interests, but we should put the interests of the defendant and the girls first. And I'm the first to admit I may entirely be wrong, but when I look at the empirical evidence in front of me, it's hard to draw any other conclusion. So.
Very well said, Jason. And we've also, I know you guys have heard me say this before, but I think it begs repeating in this case. Evidence is lost at times in investigations, certainly a 7-year investigation. And the fact that something is lost, not because someone intentionally went and deleted something because they knew it was exculpatory, does happen in cases. That doesn't prevent a case from going to trial. Rather, it affects the arguments the other side can make about credibility, about weight, about sloppy investigations. You can make those arguments all day long. There's probably a lot more there, right? The prosecution can come back and put on a witness about power surges and things that are outside of their control. That all goes to the weight of the evidence, but we're not talking about a situation where we have no idea what Brad Holder is going to say or what he did say. There are ways to find out. He will be testifying, likely, at some point. His wife is around to testify, for example. There's probably a lot of other people. The people who spoke to Brad Holder around the time can testify. So the fact that any information is missing it doesn't just apply to this defense. Essentially, you're saying if there's any case where there's any shred of information that may or may not become relevant 7 years later, is not part of the file 7 years later, means that no one can be prosecuted for those crimes. If that's the world you want to live in, I mean, truly, there will be no justice system. We don't need investigators because we will not prosecute any cases. There will be no justice for any murder victims. And, God forbid those murder victims be your loved ones. And so until there is any indication that there's prosecutorial misconduct where there was willful withholding of exculpatory evidence, the fact that there are certain tapes that are missing, not great for the prosecution, because you bet your bottom dollar they will argue all day long how bad that is and how sloppy that is. And if they're sloppy about those X number of days of recordings, then how do we know that they could carry on an investigation for 7 years, for example? But that's argument to the weight of the evidence before a jury. It's not whether the case should go forward or not at all.
So, Alice, one question for you. If all of that or some of that information was exculpatory, what would the remedy be? Wouldn't it be just to re-interview or like?
Sure.
Yeah.
I mean, you turn over exculpatory evidence that's in your possession. You don't have to create it. And so I don't know what the instance was, if there were ever recordings or that the recorder was never turned on. If it was never turned on, there's no obligation to have a recording of every single investigation or interview that you've ever had. I certainly have interviewed hundreds of witnesses without recordings just because of resources. I've interviewed people on the side of the road because we found them there and we whipped out a notepad and started taking notes, right? And so exculpatory evidence, you don't have to create exculpatory evidence. If it's in your possession, you have to turn it over, and you can't intentionally destroy things that will help the other side. And so mistakes can happen. There can be malfunctions of electronics, but no one wants to hear from me on this, because then what happens? Kevin and Anya, I mean,
the remedy would not be we never try anyone for
definitely not. No. We'd all be out of jobs. And also, that's not a world I want to live in, right? Where there's no justice. So were there other witnesses at this motion to dismiss, and how long did it go?
It felt like 12 hours in and of itself, honestly. Like, I mean, the contempt hearing kind of flew by in comparison, because this again was a lot of stuff everybody already had heard. I think
there were no other defense witnesses.
No.
The prosecution called
Steve Mullen,
who was the police chief at the time, and he spoke in great detail about how this DVR system worked. He also mentioned that he was asked in cross-examination, do you consider Brad Holder a key suspect? And he said no, because the man has an alibi.
So it was like we really went into detail about how something like this happened. Baldwin went at him pretty hard in cross, but it kind of, I don't know.
Baldwin was suggesting, as soon as you realized that this interview was erased, you realized it like 6 months after the interview. Why didn't you immediately go out and re-interview him again?
Yeah, a lot of it feels like there's a discrepancy between like how important. I mean, like, obviously the odinist theory is the defense's theory, so obviously they're going to take it very seriously. But a lot of their criticism of law enforcement seems to be couched in the fact that in like 2017 or 2020 or whatnot, they didn't find the theory that credible. And I think, to me, if we have the fact that there were 3 investigators on it and doing work on it, and they still were not able to get to probable cause, like maybe there was none. Or, I mean, it's possible that there's something there in terms of they didn't devote enough resources to it. I think we'll have to just see. But it's kind of interesting to kind of like, the one side saying like, this is the theory, how could you not see it? And like the other side's like, no, we kind of think your theory sucks. Like, that's why we didn't look into it. There were better theories. And it's interesting to see that back and forth, because it's just like, I don't know, like it's so extreme,
It got so late. This hearing went on so long. Baldwin was in the middle of asking questions on cross, and he said, "It's late.
Let's just go. Like,
I'm not going to ask any more questions." And then he waived final arguments on it.
Wait. So the hearing wasn't continued? He just ended it?
Well, earlier in the day, The judge mentioned that the defense had indicated that they could imagine these hearings going past one day, and the judge said, "I've scheduled one day, and so you should run these hearings in a way to get everything done in one day."
So what time did Baldwin say it's late? Let's just end.
About maybe 20 to 6.
Yeah.
Okay. And there was no indication by the judge that he had to wrap up by 6.
No.
No.
But he was in the middle of cross-examination when he did this? He didn't even
kind of gave up, visibly gave up. I mean, you have to like basically his 2 witnesses were kind of like, ultimately didn't really get anywhere. And then, I mean, he did some aggressive cross of Mullen, but like at a certain point, it felt like everyone was just talking, frankly. It wasn't, and like then like
were there any facts that went to the 2017 deletion or non-recording of Brad Holder's interview?
So it was a deletion. They did interview him. They talked about, hey, this FBI agent and this Hammond police officer interviewed him in this room, and
with the functioning DVR that recorded it, and it was subsequently memorialized. But then later it was accidentally.
And in August of 2017, that was discovered, and also not just that was lost, but a number of other recordings were lost from the same time frame about other cases too, not just Delphi. So there was a loss of several of those things, and so they did speak to that. And then there was a lot of argument about like, well, why didn't you tell us? And Mullen indicated that he did tell potentially like someone who worked for the defense, and so there was a lot of back and forth on.
Were those interviews written down in a written report?
Yes.
Yes. So they were put through the FBI's override system to like give a tip narrative of like, here's the summary. Baldwin woefully said that it was just 6 paragraphs, as opposed to like no one knew how long they talked to this guy, Brad Holder. So it's like, it's not clear aside from that.
Obviously, we understand the defense's frustration.
Yeah, I think it's understandable.
Oh, absolutely. I think that's absolutely right. But I know if the FBI was in there, they had to write a report. They have to write a report of every interview. And by the way, 6 paragraphs is actually a lot based on my experience because they have to write a lot of these reports. So I think this all goes to whether this actually harms the defense. Is they do have a recording of this recording in written form that an interview happened and what was said in that interview. They don't have the mannerisms and the questions the way they were asked, but it's not like it's a black hole that they never would have known Brad Holder even had an alibi at one point.
Right. Yeah, and it's like they seemingly gave all that to them. They weren't trying to hide the ball on like the tip narrative of like, better not send that to them because then they'll find out about it just seemed, I think it was like an understandable frustration and something that may be very helpful to them in a trial setting. And just maybe, I just don't understand why it was brought up in this form, because I feel like this is a team that keeps on tipping their hand to the prosecution, and the prosecution's just sitting there taking notes. And I don't feel like that's going to serve Richard Allen super well at trial. And I think you have to weigh that as an attorney. Like, do I like put my cards on the table right now with this, or do I save this to really, razzle dazzle a jury? And I feel like they consistently are just putting their cards down. And I don't, Jason's point is very interesting. I know that they've certainly built up a very, how should I say this, enthusiastic following amongst some online, in a way that's kind of like maybe somewhat fascinating, like from a sociological perspective, like standing attorneys in like an ongoing true crime case. Like what is happening with society? But, that's where we are.
And I'm only going to ask this question, even though I think it has nothing to do with the motion to dismiss, but I know a lot of people have asked this question in the chat. So I am reading your chats, is they want to know what Todd Click testified to. And the reason I say this has nothing to do with the motion to dismiss is this has to go with the Odinism theory, which is full within the defense's right to fully argue at trial. But it is not about what we are here for, a very narrow argument that a couple days or a few days of testimony that had been recorded in February of 2017 has been deleted, and that deletion somehow means that the entire case should be dismissed. So with that, apparently there was some bombshell in Todd Click's testimony. Maybe not. None of us were in the room to hear it, but I think some people heard that maybe some things came out in Todd Click's investigation that gave some sort of credence to the Odinism theory. Is that true? I'm just looking at the chats. I have no personal knowledge of this.
I'd be curious what people feel was particularly bombshell-y. I mean, to me, it was mostly a recap. He sort of indicated that in his view, it was never taken seriously enough by the so-called unified command. So, that basically they didn't, I got the sense he's like a guy who's like, this was a good theory. They didn't run with it. He talked a lot about sending Nick McClelland a letter in 2023, alerting to him to like how his theory was better and should be looked at more because he was concerned that somebody who wasn't part of his theory was arrested. So, kind of like, hey, like, I want to talk to you all about this. And then he felt that they sort of invited him in, but didn't really tell him that much, and then kind of sent him on his way. So, I get the sense that, he's a guy who's like passionate about that theory. In terms of bombshells, were there any like little details that kind of we didn't know before?
None that come to mind.
It's hard to talk about some of this because like sometimes like you might know stuff and then I don't know what other people are hearing that's like blowing their minds. Maybe it blew my mind a month ago or something. You know what I mean? Like, so I'd be curious, like, if people have something within that. I always felt that, to me, from what I, understood, and we got comments from Todd Click talking about how he didn't feel like there was a sacrifice in this case, but he did feel like the same players were involved and that it was like some sort of more interpersonal motive. And to me, that always seemed like the more down-to-earth version of the Odinist theory. And I was always confused as to why the defense didn't go with just go with what Click's saying. Cause like that, that as opposed to like white supremacists sacrificing white kids in a religious sacrifice that like, there's no real precedent for. Like,
well, on it, if I were writing a book, I'd have the answer to your question, right? So I need to explain away confessions in my book. So I need them to be white supremacists, which requires me to move away from the Click story to have a good narrative to the jury. So just
Jason's like taking out people with his book over there.
All right. Around.
That was flying Topo.
Andrew Holder was going to talk about that allegedly Brad Holder had a more extensive relationship with Abby Williams than was previously indicated.
Oh yeah, was
that the bombshell?
Maybe that was the bombshell, But I mean, to me, like, I guess I'm at a point where like I just need something else other than like what they're saying in court at this point, like, because there's been times in the past where we've gotten really like wild filings or hearings and it's like, wow, like, like
this changes
everything. And then, like a week passes and you're like, oh, or you get more context. This changes nothing. Or this is
so without even argument. And that I think is a really big deal. A motion to dismiss obviously is a dispositive motion. It could end your case. You win at that stage. And usually like you would never waive your final argument because you have it's like your closing argument at trial essentially. And you're saying there wasn't any like closing arguments at all for the motion to dismiss?
No.
Did the prosecution do anything?
No, the prosecution for the motion to dismiss was actually handled by a woman whose name I didn't catch.
I don't remember her name either.
She was very good.
She was good.
Baldwin just said, I'm waiving final arguments. This prosecutor said, I feel that the arguments that are in the motions that have already been filed are sufficient. So with that said, I waive final arguments too.
Which is smart of the prosecution because it's not their motion. They want it to be as unbombastic as possible. Man, I could come up with a 5-minute closing argument for the defense on the fly that would just like leave with the big thing, right? We all know what it is. Like, this is the messiest prosecution we've ever seen. We have a man's life on the line here. He's here sitting before you for the murder of 2 girls that he is innocent of. And you're telling me that these intentionally deleted interviews of the person who actually did it is no longer here. How can we possibly prosecute this case? Judge, if there's any justice in the system, you will dismiss this case today. Done.
You
Are you kidding me? I don't want to be their defense attorney, but I'm only doing that to show you how important a closing argument is, because when you're sitting in court, you guys sat through it all day. It's witness after witness after witness, and your kind of hard-hitting arguments, the reason you have argument is to tie together all the kind of boring testimony all throughout the day, to pull it together into a succinct argument so the judge feels the fire and thinks, well, I can't leave this bench until I deliver some justice today. So with that, did the court rule from the bench? And, what happened after that?
No ruling yet.
No ruling.
I don't think it's going to be a surprise what that ruling is.
No, yeah.
Baldwin really did just seem demoralized by the end.
The wind was out of his sails.
His witnesses were not allowed to testify. Again, the judge was having sidebars with him and the other counsel, and she was being critical of him so loudly that even in a courtroom with bad acoustics, it was not hard to hear. I think I mentioned, she said, if you don't have witnesses for 2017, you're wasting our time. Another time she said something like, you don't need to tell me the case law, Mr. Baldwin. I know the case law.
Yeah, and like
she sounded very angry. So
angry is a strong word. Like she was kind of just done. She was done for a while with some
frustrated.
Of this. Frustrated. I feel like, and like I don't know, maybe that plays into the defense's strategy to make her look biased. So it's like, look, she was mean to us. She didn't throw out the case. Like I mean, I feel like the more time goes on, though, I don't know. Like there seems to be like there's been so many like snarky things in some of their filings where they're like, hey judge, remember when you ruled on this and you really messed it up and they ruled against you? we remember that.
Not those exact words.
Not those exact. They didn't say ha ha in their filing, but like there's been a lot of that, and I'm like, I almost wonder if antagonizing the judge is like, it's almost like they're daring, like it's like a game of chicken, like trying to throw us off again, like please, like I don't know.
Great movie. Great.
Well, let's go around the room because we got to let Kevin and Anya sleep eventually. Predictions for the court's ruling on today's 2 hearings. I'll go to Jason first.
Oh, good Lord. So here's my prediction, totally based on absolutely nothing. The motion to dismiss, denied. And on contempt, I'm going to go with losing 2 weeks of pay and being found in contempt.
Jason. All right. What about Kevin and Anya?
I'm gonna mostly copy Jason. I definitely think that motion to dismiss is dead in the water, and I think that I think it's going to be some sort of financial penalty with contempt of court. I think if anyone has I think that's what people are saying like, oh, they might go to jail. I don't see that.
Yeah, I agree with you and Jason.
There you go.
That's easy.
We're boring.
Not boring. You guys were in the room, and Jason, like, I don't know, you are able to be across the Twitter webs more than I have ever hoped to be. I think the motion to dismiss, legally, there's really no basis, so it should be dismissed. I think it's very clear, even by the way Baldwin ended the day, which is to waive his argument. He knows, and he's tired because he doesn't have a winning argument. If you have a winning argument, 20-6, you're going to take 5 minutes to just stick it to them. There's no argument there. I understand why they filed it, and it was very effective because it's gotten people talking about 70 days of missing recordings. It's a great soundbite, great for the media. So I don't find it confusing that they filed it. I just think it should be dismissed pretty easily as well. As for the motion to contempt, this is a little bit more difficult because Judge Gall is having to operate in a weird space, which is that she's been mandamused and she's been reversed by the Supreme Court only with respect to the removal of the attorneys. So what I think she'll do, because I think she has a clear record of it, and she even has Hennessy in a previous filing saying that these facts are contemptuous, that there will be a finding of contempt, but that there will be absolutely no penalty. I do not think they will be fined. I do not think that any financial harm will come to them, because I think that's why they filed the motion for parity of resources today. In some ways, in some ways to hedge against any sort of financial backlash. They will never be sent to jail or prison for this. Basically, I think Judge Gall's hands are tied. I think she can find contempt, but there's not much she can do because everything else will somehow be spun into how unfair it is for them and will spin into even more filings. And remember, they can appeal. So, I think that will be appeal proof, especially because of the record and Hennessy's previous own filings.
See, Alice, this is why we keep you around.
No, we missed Brett today, but really, I'm sorry for talking so much. I'm just so excited to have all three of you on. Before we sign off and let you guys finally go get some water and sleep, is there anything else from today's hearing that we haven't covered that I know people are just hanging on every word to know about?
Oh gosh, I don't know. I feel like you guys, you both are wonderful, and we just so appreciate talking with you about this. I think we covered the real high points for sure. I'm sure there'll be some weird moments that like we remember in 5 days where we're like, what the heck was that? But no, those are the big things.
Well, thank you. And Jason, is there anything else you'd like to add? I know we barely got to touch on all the social media. We'll have you back just to analyze all the social media aspect of this.
Absolutely. I'll echo them. Alice, you're amazing. Brett, wherever you are, you're amazing too. It's great to be with the two podcasts that got me into podcasting. Never would have imagined. I love you guys and I love what you do and just glad to be a part of the family.
Thank you. Well, we're going to sign off and you're going to sign off, Jason, and then Kevin and Anya, you'll sign off too. Okay. You get to be part of the sign off. Thank you so much for the Murder Sheet and Silver Linings Handbook for joining us today to discuss the hearings in Delphi today. I'm sure this will not be the last time we discuss hearings in this case, but I hope we are able to move on for the time being. And until next time, I'm Alice.
And I'm Jason.
I'm Kevin.
And I'm Anya.
And this is the Prosecutor's Legal Briefs. Thank you, guys.
It was for me to not say I'm Brett.
You could have. We'll just have you on next time to do that. Oh, my goodness. Okay. I don't want to keep you. You're welcome to stay because I'm sure people on the chat would love for you to stay, but you guys need to go sleep. I'm sorry for keeping you 30 minutes longer than I intended.
You're fine. It was so delightful. And
we love talking.
We love talking with you.
I was expecting to get all ranty there, so I'm sorry.
You're not ranty at all. This was just the thing was this was such a black box, and you guys being there, I mean, you offer such a public service, so thank you for that.
Thanks.
Yeah,
here's a question.
Yeah.
Do you think it's going to go to trial in May?
No. What's May? No. And I wanted to go to trial in May.
I really wanted to. So.
I really wanted to go to trial next week.
I agree. There's no way.
Well, and also everything that the defense is doing outside of the speedy trial motion, which I am suspicious of, is really, the complaints about discovery, other things along those lines are all things that are going to push it on further. Now that I know they're asking that it be counted against the state's time, but that's not going to happen. So everything they're saying speedy trial, but their feet are screaming slow motion. Yeah. So
agreed.
Wow. I think their hand was forced. They needed to file that speedy motion filing, and now they have to figure a way out of it, which will actually be pretty easy. I think all of the resources motion they filed today about not getting paid, about having to review 250 pages, of documents, and then a bunch of recordings that are missing where they have to reinvestigate are all going to be the basis of why we can't go to trial in May.
And do you think, and any reasonable judge is going to let them have more time, right?
If the defense wants more time, the defense gets more time.
They're going to get more time. That's just generally the way it's going to go. Yeah.
But you did say juror questionnaires went out a couple of days ago.
What was that?
Juror questionnaires went out a few days ago.
Yeah. They have to, right? We would call juries the jury veneers because you have to, there's certain things that the court has to do by certain deadlines. But it doesn't mean that anything happens, Right. They can send out lots of questionnaires.
So weird. It's really weird. It also begs some questions, right? If they're struggling the way they are right now, it's hard to have confidence that they could possibly be prepared by now. Just like the command of the facts things that you were talking about.
Well, I think Kevin and Anya, you've said this many times before. There is a real defense to be had in this case.
Yes.
The bullet casing, the fact that no arrest was made in such a long time, the video was out there for that long, and he's a well-known person in the community. I mean, there is a real defense here. I don't think this is
Absolutely.
necessarily, you know, and then of course his confessions, which are difficult.
Can I tell you my stupid metaphor for this? And,
yeah.
and I can't even do this with you, Alice, because you're the queen of metaphors after what you said about gynecology in our last conversation. Like, I don't know why I'm bringing this, but I'm sleep deprived, so I'm going to do it. Like, this is how I, like, to me, let's think about bowling. Let's think about each pin is like a specific piece of evidence against Alan. So you have the bullet, you have the confessions or the incriminating statements, what have you. You have him putting himself there. You have, you know, just all the variety of things. I think you as a bowler, you can knock those down. I think if you bowl a strike, he's acquitted, and it's possible to bowl a strike. Right now, what I feel like I'm seeing them do is like, you know, violently kind of like, you know, like fake out with the bowling ball towards like the concession stand and like the bowling alley employees and like the ceiling. And like, I hope they just let it rip down the alley, because that's like how it's supposed to be.
The whole defense has like a bad case of, I'm not gonna use ADHD as an example, but no, I can't use that example. Let's just put it this way: it feels like they're all on stimulants and not paying much attention.
Well, it's like, because it's like I think if they're chasing a media high, I mean, I just don't like. I mean, I don't know. Like, I kind of feel like when the thing is, like, the media turns on people and cases like pretty quickly.
And especially creators, right? Like, if you're looking for something like a Hollywood deal, for example, you have to thread the needle so perfectly with the right narrative, the right outcomes. But I think, right, these cases happen, and I'm not saying this happened in this case, but, you know, the producers make the phone calls, they want to do the documentaries, they sell you on this thing, you'll definitely be, and I'm not saying this happened in this case. It's really easy to get sucked in that black hole. I've had my life story optioned 3 times. You see any movie about me? No, right? But I am not a billionaire or millionaire yet.
But so, you know what that atmosphere is like, and it's like, I don't know. I dread this. I feel like there is such a solid defense to be made here. Sometimes people say we're too critical on the defense, but that honestly comes from a place of being concerned about Alan getting the best representation possible. And for me, that is like a kind of close hand combat on some of the facts that you're toppling what the prosecution is saying with better experts or better arguments, or, you know, hey, this is junk science, we shouldn't use this. I feel like that is so compelling, and that would be so impressive, and like it would be really some great lawyering. And everything we've seen so far has been sort of getting further and further away from that. So I'm sort of maybe naively hoping that maybe at some point that there is like, I don't know, maybe it's like a fake out and like, no, we're not doing Odinism. Like, you know, I mean, that's not going to happen at this point, but like, I almost hope maybe they can firm up the Odinism thing, or like tighten it, or like don't bring in like guards and make it a Indiana-wide conspiracy where all of us are secret Odinists. Like, you know,
I mean, they don't have to stick to that, right? Like,
here's the thing. I'm fine if Odinism is the way they want to go. Seriously. But do it in the right way. Everyone has defenses and theories. The problem with this case is it's not about the case. This case is not about Libby and Abby and Richard Allen. That's the case we are before, right? If this were about Brad Holder, there can be another indictment against Brad Holder. That's not what we're at here. Everyone has the case and controversy before them. And this is a case within a case within a case within a case, except the cases within the cases have nothing to do with the actual case. They have to do with personal egos of the defense attorneys here. That's my problem with this case. And so if we can get out of the case within a case within a case, which I have no confidence that we'll be able to do at all, then really this is a travesty. So I do hope that this is reined in time for the trial. I do think, you know, a lot of people are like, it's impossible to not have a tainted jury. Guys, it's amazing how little people know about these sorts of cases.
Oh, yeah. we know people, they have no idea what Delphi is. I mean, in Indiana, like I mean, it happens. Like, it's not everybody's into true crime. Not everybody's in our space. That's hard for all of us to accept because we're so deep in this space. But like, you know, they're going to be able to find a jury. I think it's fine.
Yeah, it won't be a problem.
I don't think
absolutely.
You know what makes me so sad about this, actually, beyond like the girls, and also justice for him, because there are innocent people. Everybody deserves to have like a good defense. The families are going through this, but just coming at it from the perspective of a journalist, there is such an opportunity here for good journalism to hold everyone to account, to hold the prosecution, the judicial system, the defense attorneys to account, right? If you were really going to get held to account for your behaviors in a situation like this, I doubt you would be behaving this way. And the absence of that, and the fact that people are turning to these other kinds of creators, is really just sort of like taking that. And I know the First Amendment is a defense and a protection, but that concept of oppress, right? It's taking it and just destroying its ability to add value to society, and that makes me very sad. So,
I mean, like,
things.
We've criticized everybody in this case. Like we you know, I mean, like somebody asked us.
Yeah. Go
What?
for it. You have a
Yeah.
Yeah, go for it.
No, none, never you, Jason. But like just in terms of the public figures, the parties, we've gone after the judge, we've gone after Nick, we've, you know, I mean, like we've certainly criticized the defense. But I mean, one thing we found is that whenever you're holding or attempting to hold somebody to account or saying, listen, the prosecutor shouldn't be hiding the PCA, or listen, the judge should have like created a record before she acted, or listen, the defense is doing whatever they're doing right now. You know, it like you have a lot of people who really don't like that because they've decided that they're on a team and they don't want people to be held to account. They want to root for the team. It's like a fanification of true crime.
Yeah, it does feel like football teams or basketball teams.
Yeah, it's bad, and like people I think need to engage with this more critically. And I mean one thing I like about the way you both approach this work is that you encourage people to do that and like think about it, and like everyone can have different opinions, but you have to critically think about it and not treat it that way.
People are constantly trying to put you guys on teams, and I was in this hilarious conversation, Alice, about you and Brett on Twitter today, where somebody was like, their name is the Prosecutors Podcast. I'm like, outside of Kevin and Anya, who have I ever heard about truly looking out for Richard Allen's rights? It was your last Delphi episode. Brett is like, does anyone care? But so, you know, like I don't know. It's just maddening. It's maddening.
Yeah.
Well, speaking of Richard Allen, before we leave, I should mention, for whatever it's worth, I think today was the best I've seen him look.
Yes.
Really?
Yeah.
Okay.
Yeah, I mean, because they kept showing the same footage of him looking kind of gaunt, but I mean, he sat through a long day. Did you ever hear him talk or kind of whisper to his attorneys?
He never talks. He never talked today. He did sort of whisper to his attorneys, I guess, a few times. He has like a very wide-eyed look, typically, like very wide-eyed, kind of like looking out at everybody. And so that's what he was mostly doing.
I saw him, like his eyes would follow and look at whoever was speaking most of the time. In the past, he would just often have just a dazed look on.
He'd be like looking anywhere else.
So he seemed more engaged. He didn't seem gaunt. He seemed a healthy way.
Yeah, he looked much healthier than he had in past times. So that's good to see. It was always really ominous and kind of like upsetting to see him come out like emaciated, and it was like, geez, you know. I mean, so yeah, that was something we always kind of like note that and like how responsive he seems, because, you know, I mean, it's just and
that's just an interesting element that he's watching everything. And obviously, lay people, especially when it's your own defense, watching it, you may see it through a different lens. But it doesn't really sound like the defense presented very well today.
No, they didn't. They didn't. I mean, it doesn't give me any pleasure to say that, but they didn't. And I don't know if he has anyone in his corner who's like legally savvy enough to like see that and like try to maybe say something. But I think a lot of people equate loud and vigorous lawyering with good lawyering, and that's really oftentimes not the case, actually. And I think, you know, in his case, I mean, there was indications from his past attorneys that he seemed to be under the impression that if he got new attorneys from Rosie and Baldwin, that he would be charged, like that he would have to pay out of pocket for it. And so all of that makes me really concerned about like
what information is being conveyed to him.
Yes, like that is like a huge red flag for me, because like I don't know how if he and his family are fully informed and making these decisions and think this is right for us, then great. But if not, then like that's a tragedy.
I don't know, man. Not waving your clothes, I think, would be obvious to most people. like something's being dropped here, or having your witnesses disallowed, or like there are clues. If I were the defendant under stress, I wouldn't see it. But like as an outsider, I think if I were a family member, I'd be like, there's something really going wrong here. Unless they in advance, we're just going to do this. It's not going to work, but you know.
And
or
remember,
the big mean judge, right? The big mean judge won't let us do anything. We would have won, but she's so mean, like that sort of thing.
And don't undermine. I mean, maybe they have great attorney client relationship with him. It goes a long way when your client thinks you really hear them, and it doesn't take that much, right? Especially when he's in confinement. Phone calls from his attorneys regularly saying things like, "We are on your team," can mean the world to your clients. And so we don't know their relationship, but it's possible that they just have great, bedside manner, for example.
They might. I mean,
it's so scary to start over. Imagining myself as a defendant in a serious crime, having to explain things that I may not really like about my life, even if I'm innocent. I would hate. It's like starting over with a new therapist times 10. Like nobody wants to do it.
Yeah. Okay, Kevin, you need to go to sleep. I'm gonna be like the mother here and say, go to sleep, because you know what? We need you for probably in 10 days when the memo comes out.
Awesome. Well, this was lovely. Thank you both so much.
Thank you guys so much for everything. I'm glad you don't have to have another hearing tomorrow.
Alice, thank you for putting up with me.
Jason, thank you so much for joining. Thank you to the 196 of you still here.
Still there?
So thankful. Yeah, they're still here, man. Yeah, they want to hear you, Jason. But we love you guys. Thank you, both of your podcasts, for all you do. And I'm sure this is not the last time.
Have a great night.
Good night.
Bye, y'all.
Woo! Alice.